NACDL is the association of the nation's criminal defense bar.
Okay.
That's because we did it this morning.
Chris Fabricant is the Director of Strategic Litigation at the Innocence Project, and among the other work Chris does there, he has been doing a lot of work dealing on strategies and materials to litigate these cases with erroneous hair evidence, and a lot of this is part of the collaboration between NACDL, the Innocence Project, the FBI, and the Department of Justice to review these cases with FBI examiner erroneous evidence. We also have here today Peter Neufeld, who does not need a long introduction. You all know Peter. He, along with Barry Scheck, co-founded the Innocence Project, has, along with the Innocence Project, achieved exonerations in around 300 cases through DNA testing. He also serves on the New York State Commission for Forensic Science. And we also have here today to talk to us Sandra Levick, who's the Chief of Special Litigation at the Public Defender Service for the District of Columbia. Sandy has so far secured exonerations in 4 cases where men were convicted based in part on erroneous hair comparison evidence. And these cases basically served as the springboard, got the ball rolling for this review of FBI hair examiner testimony. You know these names. They're Donald Gates, Sante Tribble, Kirk Odom, and Cleveland Wright, and she's working on some others. So I'm going to turn it over to this panel of experts.
Hi. So I wanted to start by saying that yes, that this talk is going to focus on hair microscopy cases, generally speaking, but I think that and I don't think so. I know so that these arguments should be applicable to all discredited science cases to a greater or lesser extent. So we're going to be talking about that in the context of hair comparison cases, but think dog scent analysis, think CBLA, think bite mark analysis, all the other junk sciences. These types of legal theories should be applicable to a greater or lesser extent on all of them. And I want to make sure that we're clear about what we're talking about, and I'll go over the hair microscopy, like the errors that are being conceded by the FBI in a little bit greater detail in a minute. But just to refresh those of you who aren't well versed in the 2 hypotheses of hair comparison analysis, is that one is that a properly trained hair expert can make an association between a known hair and a questioned hair. And number 2 is that if they can make such an association, that they can give a scientifically valid estimate as to how rare or how common that association is. And the FBI's concession is related to hypothesis number 2. In other words, they are still believers out there that they can make these associations, but they are conceding that they really have no idea how rare or how common an association between a known and a suspect hair is. So that is the focus of the false evidence arguments. Some of the other arguments that we're going to be talking about is where there's an effort by these experts to give some probative weight to the association between the 2. Lastly is that these cases are, the hair microscopy audit, many of the cases are going to be DNA tested, and that will be an entirely different type of litigation. This discussion is non-DNA cases in discredited science arena.
The only additional comment I would make, and by the way, I'm not going to be giving any major presentation. It's these 2. I'm only serving the role which was of a long-standing character in the Yiddish theater. I'm the kibitzer, and that's it. But the only point I wanted to make, and it's interesting that both of this morning's speakers each addressed problems with statistics. And putting hair aside, okay, when Chris talks about 2 hypotheses, one is that they do good bench work, it's reliable, it's reproducible, and 2, even if they declare a positive association, what's the probative value of it? That's hypothesis 2. That applies, it applies to shake and baby, it applies to all the disciplines that the first speaker addressed, and it applies to all the pattern and impression evidence disciplines that we see from state crime labs, federal crime labs, and everybody else. Sorry.
Right, and I would say, just building on what Jack was talking about this morning in terms of the relevant scientific community, that's why statistics and probabilities experts must be part of that relevant scientific community, because they understand the problems that are associated with the second hypothesis. These are the legal theories that we're going to run through today. They're all familiar to you, I'm sure, as an overview of what we're going to get into. So, newly discovered evidence. Broadly speaking, this is kind of an all 50 states vary to a different degree, but fundamentally they require reasonable diligence, that you should have been looking for it and been looking for it a long time, that the evidence is material, and that you would have gotten a different result had this evidence been known at the time of trial. Fundamentally, on the hair microscopy case audits, you're going to get two types of cases. You're going to get the cases where the FBI is going to send the defense, the prosecution, and the defendant him or herself a letter that concedes error in a particular case. Obviously, in those cases, the timing of the discovery of the new evidence will be the receipt of this letter. That's not a problem. The other cases, the state hair cases and other discredited science cases, this is going to be an interesting development. With the hair stuff, you can probably put it at the date of the FBI's public concession, which was in July of last year, so really you got to get on this now if you got one of these cases, because I think that prosecutors will at the very least point to that particular date as the date where this became public information. But apart from that, and something that we'll be discussing and that it relates to a lot of the different theories, and this is true with all discredited science cases, is that really when, it's kind of the opposite of Fry, is like when that twilight zone that we're talking about where it becomes generally accepted, this is the twilight zone where it becomes generally not accepted anymore. And it's like putting a time on that is going to be very difficult, because as you can see what I noted here, and I say in footnote 5 of the memo, I cite some older cases that talk about some of the problems with hair microscopy. But really, if, and Sandy is going to go into a little bit more in this 1985 symposium that the FBI had, that they knew some of the problems with hair microscopy for a long time. But there has been the knowledge, the problem, the statistical problems with hypothesis number 2 have been known for a century. And I think that the memo that has been distributed, one of the last exhibit, is a 2-page, so I say 2 pages so you can get through it quickly, affidavit from Professor Karen Cafeter that talks about the hypothesis number 2, essentially, in that you have to have information about how rare or how common a particular variable is before you can make a probabilistic claim as to how probative that type of evidence is. So this is going to be an issue, is when you ought to have known that this was bogus science and in litigation, and it relates to some of the other theories we were talking about. And then reasonable diligence. These are always also difficult in discredited science cases, is when should, how could you come across this information? And the Department of Justice has, and this is really extraordinary, is on these hair comparison cases, they've agreed to waive any procedural barriers that might otherwise exist to relitigating these hair microscopy cases. So obviously it's great if you get one of these letters and you're talking about an FBI case, but it should be persuasive to state courts to reach these cases in the interest of justice. If you say, listen, the hair microscopy stuff is the same in federal court as it is in state court, it's the science that we're talking about, and if the Department of Justice is willing to waive procedural barriers to determine really essentially the materiality of the evidence at issue, so should you. And then I put in some language about some of the pragmatic barriers to a prisoner who's been serving 10, 15 years on a bogus science conviction. How diligent can that person be? How much access does that person have to literature, to understand, to media, to understand that this stuff was bogus? And then I finally mentioned this. This is some language that was taken out of the ASCLD lab notification to crime lab directors around the country. And for those of you who aren't familiar with ASCLD lab, it's the primary accrediting organization to crime laboratories in the United States. And they noted in this, and this is also an exhibit to the memo that some of you have, they noted that there is an ethical obligation when we understand that testimony that has been given previously in criminal trials, we now understand was wrong, that you have a duty to go back and correct the record. So I think that cobbling together some of these arguments, the reasonable diligence problem should be able to overcome that in state court litigation. Materiality. The materiality thing, and there's also a lot on, in your memo on materiality, and I think that the CSI effect, for those of you who aren't familiar with it, typically it's a prosecutor's lament, and prosecutors complain that, oh, I can't get a conviction because all these idiots who are watching all this TV, they think that we're going to have conclusive scientific evidence to get any convictions, and so they put in this junk science because they have to. But it can be flipped, and many have done this, in that it's really, the argument is that these jurors, because they watch CSI and whatnot, expect the science that's introduced to be objective, neutral, and conclusive evidence. And so when you're talking about in post-conviction litigation science that we now know was not valid, making this argument as to how material it must have been in this particular case, because this is from a scientist, right? And they're using scientific jargon, and they're supposed to be neutral, and they're not supposed to have a stake in the outcome of the proceedings. I think the CSI effect in post-conviction litigation can be quite powerful, and there is some good case law on that I've put into this memo. And then another in terms of materiality, and I think that those of you who've been practicing for a long time, and you get back to this when you were a baby defense attorney and you got your first piece of forensic evidence, a lot of people just adjusted their trial theories accordingly to incorporate this new piece of evidence. So if you can look at a record and note, or maybe you can contact the defense attorney and say, is there something else that you might have done had you not had this hair comparison, had you not had this bite mark, had you not had the CBLA, that's also quite powerful. And I know that we're working with the Arizona Innocence Project on a case just like that, a CBLA case, where the defense attorney, who's now a judge, gave an affidavit saying, I did not pursue this alternative shooter suspect because of the CBLA evidence in that particular case. So I think that is also something to be looking at when you're looking at a record at the whole. If you can see something that, a defense theory that was necessarily precluded by this piece of so-called scientific evidence. And some other research that's in the materiality aspect. And this relates to really all the theories, that the materiality is always going to be an issue. And so this particular slide, the last two slides, will be related to essentially all the theories that we're talking about, is that Michael Sachs has at least one study, and there are a few, although the research is not particularly robust in this area, that's the impact of scientific evidence on jurors is an emerging area, and I know that Bill Thompson's doing a study right now, Brandon Garrett has one on fingerprints, and the one that I cited in the memo is essentially saying that cross-examination is ineffective at demonstrating the flaws in particular science, is not sufficient to correct jurors' misapprehension as to what the science actually means and how probative that evidence is. Also something that's very good to kind of juxtapose with the CSI effect. So when you get these cases where you get a defense attorney who actually did a reasonable cross-examination, point to this literature that says, well, it doesn't even matter. Once you get the scientist on the stand, it's all over for the defendant. Some of the pitfalls. And I should say, in advance of all these, there are tensions with all the theories that we talk about, and it's going to be very based specifically on the facts of your particular case as strategically what you want to argue. And with a newly discovered evidence, well, first, of course, we have this is a very, very high standard. And compared to the constitutional arguments we'll be getting into in a minute, a difficult standard. Most of the litigation in this area is done through newly discovered evidence litigation. And the one thing I want to emphasize, and if I fail to emphasize it enough, let me emphasize it again right now, is that you must be pleading constitutional theories as well in case you lose in state court. And obviously, we're talking about state court litigation right now. Is that if you don't, then you have no recourse in federal habeas law. So some of the other constitutional theories must be pled. And just going back to the California and Maryland examples, particularly in California, the newly discovered evidence standard is incredibly high. It must point unerringly to innocence. So the constitutional theories are much more favorable in that. And in Maryland, as I point out, it has to be pled as actual innocence. But what I see in Maryland is a lot of stuff that is pled as actual innocence, but is really just newly discovered. So some of the tensions with some of the other arguments is and we're going to get into false evidence, is that when a prosecutor is putting on an expert, and at the time the expert and the prosecution is under the impression that the science is valid, and then you're trying to make the argument later that this evidence was false, the fact that, that this is newly discovered is in tension with that. In other words, that how could they have known if we are now discovering today that this was bogus science? So you have to consider this as we're determining what theories you want to argue with. It's also, if you're doing an IAC claim, which is the majority of this constitutional work in this area is on IAC claims, is that if it's newly discovered, then your defense attorney didn't fail to exercise reasonable diligence in failing to challenge it at the time of the trial. So certainly you would want to raise it to everybody who got the letter, and then newly discovered, depending on the facts of your particular case. Before we move on, anything on newly discovered from you guys? No? This particular, for those of you who were at the conference last year, and I think what sparked my particular interest in this area of the law was Jeff Fisher gave a talk urging practitioners to advance this particular type of an argument in these discredited science cases. And really what it means is that where you have, and this is language that I put into the memo as suggested to you, and in arguing these types of cases, is that it's really two strands of due process law that we're talking about. It's a fundamental fairness that begins with Chambers, essentially, and the Sixth Amendment right to counsel cases, and that these are core fundamental fairness issues, and that the idea is that if you have a piece of scientific evidence that the court, that the defense attorney, that the prosecutor, that everybody believes may have some minor flaws, but is essentially valid and reliable science, the defense is really precluded from a meaningful challenge of that type of evidence. And that we're here, everybody thought the world was flat, 20 years go by, we realized it was round. And that problem is essentially a breakdown in the adversarial system, is that there is no meaningful challenge to what we know now is discredited scientific evidence. And so what I've highlighted in the memo is just some of the language that talks about fundamental fairness, and what that means is, in terms of the Sixth Amendment, is that was there meaningful adversarial testing of the evidence at issue? And if nobody really challenged it, and today we know it's no good, then there hasn't been meaningful adversarial testing of that particular evidence, and it's fundamentally unfair. And I think that this is particularly, I think I have a slide on this. Yeah. I think this is particularly true if you're litigating shaken baby cases, older arson cases, bite mark cases, gunshot residue. These older cases where really a lot of people were flying blind, and there was no cross-examination, there was no pretrial challenge to the admissibility of this, and we now know. So I think that type of a factual scenario would be a good place to start this. And when the hair microscopy cases, and we're going to talk a little bit more about the challenge in this area, is that when you have a state hair examiner and there's been no meaningful adversarial testing of the hair comparison cases, fundamental fairness, I think, should be pled with other constitutional theories on this. And then particularly if you get, and we'll get more into what false testimony means, is that when you get like a hair microscopist that's inventing statistics or saying that your guide to the exclusion of everybody else on the planet, I think that is going to resonate more with the fundamental fairness thing. And I should say, and this is true with all of them, and Sandy and I were talking about this morning, is that all of litigation really is fact-driven, story-driven, and that if you look at almost all the cases that are favorable in the memo that you have, is that the court wants to do something about it, right? And that the defendants sound innocent, or that they really got screwed in a significant way. And so if you can make that argument with a straight face in a post-conviction setting, then I think that it's much more the persuasive argument. And the other thing about fundamental fairness is that when you're getting into federal litigation is that you have to, under the AEDPA, have clearly established Supreme Court precedent to overturn a state court's affirmance of a conviction. And the false evidence arguments that we're going to get into in a minute, that's pushing the envelope in this area in ways that the courts are not going to consider clearly established Supreme Court precedent. In my view, I'm not sure if anybody else on the panel disagrees with that, Sandy might, but I think there's no harm, and certainly there's potential great benefit of introducing this type of an argument. The false or misleading, and I'll credit Sandy for pointing the Alcatora case, which I think she's going to talk about more, is that essentially what it is that the elements is that is that the testimony was actually false, and that the prosecution knew or that they should have known such evidence was false. And the relief is if there's any reasonable likelihood that the false testimony or evidence affected the judgment of the jury, which is a very favorable standard. So I'm going to get into a little bit into the hair microscopy thing, and just so we understand what we're talking about when we talk about false testimony. Again, these are the two hypotheses. I won't repeat them, but we're talking about hypothesis number 2. This was the NAS report, and this is kind of the history of how we're getting to the false evidence. And this is false, and Sandy will talk about false in kind of the traditional I'm lying sense of it. And I'm talking about false in false as a matter of science aspect of it at this moment. And so when the NAS report came out, it was essentially a different, much more respected body saying the same thing a lot of people had known for quite a long time. But what they found is that there is no scientifically accepted statistics exist about the frequency with which particular characteristics of hair are distributed in the population. That's essentially hypothesis number 2, right? So we're not saying, we don't know how rare or how common it is. They pointed that out. And there was no scientific support for the use of hair comparisons for individualization in the absence of nuclear DNA. And this is where we're saying it's your guy to exclusive everybody else on the planet. Then Peter, and amongst others, negotiated this statement with the FBI that essentially mirrors what the NAS report says, and Sandy will talk about later that they knew, the FBI knew this as well before this particular statement was made, but it's mirroring what the NAS report said. And I think that this is very important when also in litigating trace evidence claims. This statement by the FBI, hair comparison on the limits of science, they're talking about hair microscopy, but it's relevant to all trace evidence. Where you have no information about how rare or how common the particular variables are, which they don't have in ballistics, fingerprints, bite marks, tire treads, none of it. This should be a relevant argument. And the fact that the FBI is conceding error in this should be used as leverage in all these other types of cases.
The only comment I would make is even if you go back and you look at the presentation made by Kate and Keith earlier, in all these forensic disciplines, there was historically a failure on the part of the prosecution witness to take into consideration fundamental principles of statistics and probabilities. And in just about every forensic discipline, even beyond patterns and impressions, to things like shaken baby or arson, there are assumptions involving statistics and probabilities. And like the first speaker said this morning, you have to attack those assumptions. And each of these people are not only making assumptions, they're actually making false assumptions. Because in every instance, they are actually misusing statistics and probabilities. And we're arguing that if you're a doctor or you're a forensic scientist, either you knew or should have known what are the proper principles of statistics and probabilities. And that's why it's false evidence. Go ahead.
Right, and the debate, and to the extent that we get into it, is are they deliberately lying or are they stupid? You know, so you have to draw your own conclusions as to, I think, good arguments can be made for both. These are the 3 error types that are being, that the FBI is conceding. This is essentially what I'm calling individualization, is that the examiner stated or implied that the evidentiary error could be associated with a specific individual to the exclusion of all others. And if you look again at Exhibit E in the memo, and it's downloadable from the NACDL's website, is that there is going to be some debate, I'll put it, between you and the FBI as to what individualization means. As to what that means. And what you're going to see is that it was consistent with having come from a particular person, or that it's consistent with that they were microscopically indistinguishable, the two hairs. Or and you get that same type of language in bite mark analysis and all the other trace evidence that you see, is that it has kind of the appeal of when you're reading a transcript in a post-conviction setting, of it being kind of a conservative statement. But the reality is, and this is true with some of the research that's done on the way that jurors interpret these types of words, like consistent with or match, or those types of words are not read as a conservative statement. What they're read as is individualization. So when you're looking at these types of transcripts, don't look for necessarily for saying it's him, nobody else on the planet could have done that. That type of language that I have highlighted there, they used a lot too, and it's essentially individualization language. You may get a bit of a fight on it, but that's the argument. This is the two, and this is what the NAS language and the FBI limits of science language is that any kind of statistical weight that they give to it. You know, if it's something that's pulled out of thin air, or that they say that making such a finding would be very, very rare, and that, or something that suggests that it was a very small chance that anybody else other than the defendant is the source of the particular hair. Error type 3, and this is the one that is.
The only thing I just would add to that is that you got to just think about it in terms of common sense. When an examiner of anything says that a certain event is rare or common, the words rare and common are simply substitutes for some probability, and a fraction, 1 in 6, 1 in 20. And if they don't have any data for a fraction, then they don't have any basis to say that something is rare or common. It's that simple. And the use of rare or common in that situation becomes false evidence.
This is error number 3 that I don't want to make a statement as to how rare or how common these particular errors are, because I don't know the pool of errors. But anecdotally, I have seen this a lot, and there's a lot of, and Sandy's going to talk about this in the false evidence context, is that there is evidence, not only that, I mean, you'll see these in particular cases, but you're going to see evidence that the FBI knew about this particular problem regarding the first and the second type of errors. And to get around that, they came up with this, and that's essentially using their own casework, and that the number of times they were not able to distinguish between two questioned hairs, or sample hairs, I should say. This was from, and this is, I think it's Exhibit D, right, in the memo, the entire deposition that Peter did in the civil Donald Gates case. And this is really the money quote. And basically what they were talking about is error type number 3. And I think that I recommend the deposition to you, because it will also give you some flavor of the history of this stuff. And the questions kind of leading up to it are talking about, well, do you know anything about statistics? Oh, I'm bad at stats, I flunk stats, you know, blah, blah, blah. And, you know, they get further along, and then they say, okay, well, concedes at a point that yes, I know that we couldn't do individualization, I couldn't do probabilistic testimony, and that we had this other way. And what he says is that, was there a discussion, i.e. conspiracy, amongst any of the FBI agents or examiners who said, you know, since we don't have databases and we don't have, you know, real probabilities or scientifically valid probabilities, let's try to use these numbers in lieu of real probabilities. And he says, we've had discussions to that effect. Yes, important concession. And some other highlights from this, and this is, and we'll talk about imputing this type of knowledge to the prosecution in a minute, but they essentially concedes that they knew that they were taught not to give individualization testimony. So if you see that and you're trying to make a false evidence claim, is that, you know, the deposition is evidence that's saying that we knew that we couldn't do this, and yet we made that anyway. And this is another, and what's also important about Agent Malone, this is, what's Malone's first name? Michael Malone? Michael Malone, is that it really speaks to the culture and the shared understanding in the FBI's hair and trace evidence unit for 2 decades. And these examiners testified around the country, and they trained hundreds of state examiners to give the same bogus testimony that they've been giving. So the deposition is important for the concessions made, but it also speaks to what they understood and at the time and during his 20-year tenure, and that he knew that, that you can read it yourself, but essentially is that we don't know. We don't know what we don't know, and they knew that they didn't know it, right? Not to sound like Donald Rumsfeld. The strongest conclusion is that you can make is consistent with, although that's what he says, and you folks should have a dispute with that. And this is from Spencer Sue. Did I mispronounce that? Sue, right? In an article in the Washington Post. And they says out loud in print, Justice Department officials have known for years that flawed forensic work might have led to convictions of potentially innocent people. Officials started reviewing hair comparison cases in the 1990s after reports that sloppy work by examiners at the FBI lab was producing unreliable forensic evidence in court trials. Instead of releasing those findings, they made them available only to prosecutors in affected cases. Now this is something that I have found is maybe a bit more compelling than Peter and Sandy, but you'll see in all of not all, I haven't seen them all, but if you look at the forensic evaluations in many of these cases, you'll get, and also in the testimony, you'll get disclaimers. And it's, the highlighted in red is usually what they say, it's that noted that hair comparisons do not constitute a basis for absolute personal identification. That's important because, and particularly where you don't get DOJ letters, is that what you're going to see, and it'll make sense with an IAC claim, is that when you get that type of disclaimer, and then you get testimony that essentially deliberately undermines that disclaimer, the prosecutor should know or knows that they're presenting false evidence, right? And that the defense attorney sitting there in court with this forensic evaluation has that disclaimer in his hand and doesn't do anything to attack the individualization or probabilistic testimony. That's IAC. I mean, they told you, they admitted that what they're doing is invalid, and you don't do anything add about it when at trial. And this was a transcript, and Peter assured me this is not the norm, but nonetheless, I think that in this type of situation where you have a prosecutor that is going out of, I think this was her way, this is kind of, I have seen this in more than one case. Now, in my own personal opinion, this is the hair microscopist, then my opinion then is based on my own experience and also on the comparisons to my own hair standards. So there's a difference between what the caveat says, never mind that, and what my personal opinion is against the difference between the units and personal observations. Does that caveat statement alter your opinion in this case, sir, about the hair that you found on the defendant's clothing was that of the victim's? No, it doesn't. It's your opinion that the hair did belong to the victim. It's my personal opinion, that's correct.
So the only point that's really, the only distinction you have to be aware of, actually, Barry and I are part of the New York Commission, and we were discussing these hair issues with crime lab people, prosecutors, judges, all kinds of people, and they didn't get it. That they thought as long as the report and testimony include this disclaimer, then they're covered, okay? As long as they don't testify inconsistent with the disclaimer. But what you have to remember is there's a huge difference between simply agreeing that I can't say that it's his to the exclusion of everyone on the earth, but I can say that the chances are 1 in 1,000 that it's his, or the chances that it came from anybody else are very rare. All of it is unscientific, all of it is invalid, and just because you give the disclaimer doesn't mean you're then free to give that other nonsense.
And you can be sure that the prosecutor is going to pick up the disclaimer and it's going to be sentence number 1 in their brief, so be alert. This is what we talked about before. In terms, should have known that it was false. This is basic science. Again, I point you to Karen Cafeter's statement, I guess, about the testimonial errors that have been known for some time. I think that this is going to be a challenge in the false evidence arena, particularly when you're talking about non-FBI, non-hair comparison cases where the experts themselves have not made any concessions on the basic science, is that when you talk about, like, for example, if you contrast testimony that a bite mark examiner or a fingerprint expert gives, and you contrast that to what the NAS report says is valid science, you know, it's all false testimony. And I think that absent additional evidence that Sandy is going to get into and that I just talked about, the false evidence is a heavier lift when you're just talking about basic science. I think I talked before about that the false evidence undermines potentially the newly discovered evidence, and that it's the knowing presentation of false evidence. And this is the second problem here, I think, is significant. And there is a number of cases that are in the memo about imputing knowledge to the prosecution in these cases. But I think that where you have a state hair examiner who is a cop who was walking the beat, you know, for 10 years and then got promoted to the I guess it's a promotion to the forensic unit, and then took a 2-week course at the FBI, you know, academy and learned from the feet of the masters as to that, you know, this is the kind of bogus testimony you need to be giving, that it's going to be a heavier lift. The hair, and Sandy's going to talk a little bit about, like, that probably all the hair comparison experts knew or should have known because they sat through, like, to the extent that you should know anything about what we're talking about now, is that you were sitting here at the time when this was told to you. So if you get an IAC claim later, it's like, Fabricant told me about that. It's essentially the same thing, is that people sat in these symposiums and listened to some of the problems with hair microscopy and then went out and gave the testimony anyway. And do you have a, I know that was, okay, so we had lots of debates about that. And then you look at the false testimony and jurisprudence around this, and that it's almost always, when you're talking about experts in particular, is about somebody lying about their credentials. And I think a point that I put into the memo is that, and it has to be, and it goes back to the materiality discussion that we had before and the CSI effect, is that really, what's more significant, right? That somebody, you know, went to Howard Community College and it didn't go to Howard or Harvard, or is it more significant as to the actual conclusions that this expert gave in the case? So the distinction is to our advantage in terms of these false evidence cases, because they're almost always about lying, like, about credentials, which is bad, yes, but lying about a conclusion is much worse. So I think that testimony, and again, this is an emerging area of the law. It's only in the last couple of years that courts, like the Shake and Baby stuff and the arson stuff and the bite mark stuff, not as quickly as I would like, but is that it's emerging that there are problems with these disciplines. So these false evidence arguments are somewhat novel, but the jurisprudence in the area, I think, is distinguishable in a very positive way for these types of cases. Brady. So in this particular, you know, is like and this is strong language, and I'll tell you that the original drafts of this memo, I wasn't as persuaded that it was essentially a conspiracy, that they had invented these statistics. But Peter is very persuasive, supplied me with lots of documentation as to its existence, and I am now persuaded that it was, is that they invented this stuff because they were getting urged by prosecutors because they needed numbers. They needed something to give probative weight to this association. And they deliberately invented these statistics to the extent that you can believe Agent Malone and all the other, and that they knew that there was a problem, and that they used this to deliberately mislead jurors. And they did it probably because they were getting pressure from prosecutors to, you know, this is essentially meaningless. I need more. I need this to be more powerful evidence, and they provided it. And the language that I think is really excellent, that you can always contrast all this with, is that in the FBI's statement as to the limits of science, it says the strongest thing that you could possibly say was that it could have been the source, right? And that you get, in all these cases, evidence that essentially to scientific certainty that it was the source. You contrast those two things, and you know that they knew that they had a problem, and they were convinced all these defendants are guilty. I said, probably, I don't know, but they invented them, and that's the Brady evidence that we're talking about. In the other discredited science cases, Brady is a heavier lift. And I would say, like, for example, in bite mark cases, a very useful strategy, to the extent that any of you have these in post-conviction cases, is going to other experts themselves in these small guilds that we've been talking about, is that they are aware of each other's casework. And if you have somebody that's within these guilds but considers themselves progressive, you know, somebody who hasn't been ready to abandon the discipline entirely, but feels like part of the scientific community and wants to embrace the NAS report, if you go to those people, and this is particularly true I know from experience in bite mark cases, is that in these older cases where somebody really pushed the envelope, you can usually get some evidence that these experts doubted their own opinions, or that they had some reservations about what was going on in this particular case. If you can get an affidavit from somebody like that, you can make an argument that it's Brady evidence. Again, imputing the knowledge in that type of situation is going to be a challenge.
See, I actually think you can go one step further, Chris, which is that in the hair cases, when you see what is the proper statement, it's not just that they're allowed to say the hair could have come from somebody, but whenever they say on direct examination the hair could have come from somebody, valid science would require them to put an error bar on that, okay, or what we call sort of the measurement of uncertainty. And the error bar where you don't have measurements would be that the prosecution witness also has to say, when I say it could have come from him, that what I'm really saying is that he simply won in a pool, the size of which I don't know, okay, that could have also produced it. And once you add that error bar, you are really seriously diluting the probative value of that evidence. And that would apply to, frankly, shaken baby. That when someone says that I think that this is, that this could be abusive head trauma, that they have an affirmative duty on direct to include in their testimony that measurement uncertainty. And if they don't have statistics and probabilities to back it up, then they have to say, but it also could be an accidental fall. It also could be all these other things. And it's the failure to say those other things which is the Brady violation.
The imputation is going, like the area of law that we're talking about in terms of imputing the knowledge of experts to prosecutors is, as part of the prosecution team, is not an insignificant challenge in this. I think, and I know that it briefed, and I think Tucker Carrington is in the audience on the case that we were working on, is that where you just had to basically just say it. They're part of the prosecution team because we didn't have anything directly on point saying that, you know, this expert. It's, I think with FBI agents, particularly in federal cases, it's much lighter lift, and there's good case law in that area. It's true, and I know at least there are some Florida cases that hasn't really questioned whether or not you can impute this knowledge. But I think that you can anticipate an argument that a retained expert, particularly one that is not paid by, isn't part of the local state crime lab. So for example, again, bite mark experts or some independent expert, medical doctors in the shaken baby syndrome stuff, is that if you have somebody that has no official role with the state, imputing that knowledge, I think is going to be more difficult. The nice thing about, of course, about a Brady claim, unlike, well, some of the others that we were talking about, is good faith is relevant, and that I think it's important to point out that they have a duty to learn a Brady material. So some of the problems, statistical problems that have been known for some time, prosecutor has a duty when they put an expert on the stand to discover the scientific problems with the testimony that they proffer to the jury as valid and reliable science and emphasized in closing and what have you. And the impeachment material is also there. The higher threshold, certainly than for relief than in false evidence claims. Again, it's more challenging, I think, with state hair examiners. And I think that was it, and this is true with IAC, I can mention it here as well, is that the, well, it's not part of this memo, but I think that one of the things that's important to note is that when you're talking about materiality again, and you're talking about usually when you have to have relief means that the evidence was not overwhelming, is that Brandon Garrett did a study, I think it was the first 250 DNA exonerations, that some incredible percentage of these had been argued on appeal that counsel was ineffective for failing to challenge the evidence. And they won on the first prong, but they lost on the second prong in saying that, well, the evidence was overwhelming of people that were factually innocent. So it's a good study to point to when you're talking about that particular argument. Again, the IC, it's an alternative to the newly discovered. I think it's important. One of the things that as an alternative to the newly discovered evidence, IC works. There's some good case law that's included in that. And I think, again, it goes back to the facts of your particular case. If you can make the court care, they're going to be willing to find IAC claims in this, because most of the better verdicts, or better post-conviction decisions, I should say, have been on IAC grounds lately. And you look, and I put out, you know, this recent Supreme Court case, a good Florida case, like courts that have not been necessarily friends of the defense bar, that have been willing to find IAC claims in, and there's ballistics testimony, or serology one. The SCOTUS opinion is really excellent in this, and towards the end they talk about, in the Hinton versus Alabama, they cite Peter and Brandon's article, and they acknowledge again that they say that they've acknowledged that there were serious problems with forensic evidence, and that I think should be, that language should be in all briefs, in all discredited science briefs. The Supreme Court is acknowledging this, and they've done it a couple of times now. So IAC is certainly particularly valuable, and I think, again, it's because courts haven't really known what to do with these types of cases, where over the course of a decade, that we come to learn that this only evidence that's tying this particular prisoner to this particular case is really faulty forensic sciences. They're looking for avenues of relief, and it's going to be IAC often that they fall to. This was the standard. Despite what I just said, and I think, again, it's because the courts in those particular cases were persuaded by the facts, is that courts are very, very reluctant to find IAC. Very, very reluctant. And again, this is the standard, the Strickland standard that we all know and hate. And the second claim is where these often fall, you know, and that you really have to pound on the materiality of this particular scientific evidence. And then again, I think it's worth pointing to all these innocence cases where courts always found overwhelming evidence of guilt. Again, you have to concede that the problems were known, have been known for some time. You run into problems with the due diligence aspect of it, and then IAC has to be critical. On hair comparison cases, often it wasn't the linchpin of the case. Some of the other forensic sciences that we discussed today, it often is the single most significant piece of evidence in the particular case. That's it for me.
PowerPoint challenged. And I don't think you have this in your materials, so let me just start out. The handout that Chris and the IP team did is fabulous. It's got lots of case law advancing all these different theories. I just wanted to say a couple things before I start in on my very concrete suggestion about how, at least I'm attempting to litigate a NAPU claim, and I'm going to ask for all of your help. One of the things I wanted to say just overall is that these are competing, sometimes antagonistic theories, but they're also complementary. And you can also use problems in one to advance a theory in the other. And let me just give an example of what I mean by that. First of all, in terms of newly discovered evidence, it's been known for a very long time. There have been criticisms of microscopic hair analysis for a long time. But we think that the fact that the United States of America, through its Department of Justice, has conceded that their agents, special agents of the FBI, have gone around the country in hundreds or thousands or tens of thousands of cases and given what they acknowledge to be scientifically invalid testimony is a watershed moment. I also think, with respect to, so yes, it's been criticized, but there's something new that's happened here. With respect to ineffective assistance of counsel, there's a recent case from the Pennsylvania Supreme Court where one of the arguments was well, the attorney should have brought a challenge to the admissibility under Fry of the hair testimony. And the Pennsylvania Supreme Court in 2011 said, appellant's argument regarding Fry is patently meritless. It ignores the fact that at the time of the trial, a vast number of jurisdictions had determined that human hair analysis is an accepted and reliable scientific method. So that's your answer to, well, why is this new? Well, it's new because courts have accepted this for decades, but now we have the acknowledgement that there's real problems here. So anyway, I invite you to really study the memo, look at those cases. I think it's really great. I'm going to talk about a case that I'm bringing right now. The pleadings are in your file, in your materials that you can download, called John Doe. But John Doe is Michael Jones, and I spoke to him last week, and he said I could use his name. So let's see if I can do these clickers. And I think this is just really sound, constitutionally sound argument that does not necessarily require invalid science. I just think that they lie. And I think that there's a basis for showing that they lie. But they don't have to lie. My first point is all they have to do is mislead. And Alcorta is a favorite case of mine. And I'm just going to set it up for you. And have they no shame? We can say that about a whole host of prosecutors. The difference in Alcorta was the death penalty or not. He was charged with stabbing his wife to death. He admits the killing, but he claims that he had done it in the heat of passion caused by adequate provocation when he discovered his wife, whom he suspected of infidelity, kissing the man in the car. The man is the only eyewitness to the murder. The prosecutor ends his examination of that witness as follows. Were you in love with the decedent? No. Was she in love with you? No. Had you ever talked about love? No. Had you ever had any dates with her other than to take her home? No. Well, just when I brought her home from work. Just when you brought her home from work? Yes. What the prosecutor knows, and the witness knows, but the jury does not, that the witness had admitted having sexual intercourse with the decedent on 5 or 6 occasions. So everything that he said in answer to those questions is technically true. They never talked of love. They just screwed. So you will sometimes hear courts say, well, the NAPU claim is a perjured evidence claim. It does not have to be perjury. This is from the 1950s. This is the Supreme Court saying that it is a due process violation. It is fundamentally unfair when the state knowingly misleads the jury in this fashion. So it doesn't have to be perjured. So the law enforcement expert, we can make the argument, and sure, there's cases that go the other way, but the law enforcement expert is the state. This is a NAPU claim that we're talking about. And in NAPU, the court says, a conviction obtained through use of false evidence known to be such by representatives of the state must fall under the 14th Amendment. Representatives of the state. And law enforcement experts of the kind where it's the sworn deputized agent of the FBI or of a state crime lab, these aren't independent laboratories. These aren't doctors that they, bring from a medical faculty. When the state relies on their evidence, even if it's unknown to the prosecution, if the expert knows that he's giving false or misleading testimony, then it violates due process. And I have, in my motions, I cite some materials that aren't on these slides, geared particularly to the jurisdiction where I practice, which is the District of Columbia, but some other cases as well. But anyway, here's a state case where they talk about the false credentials of ballistic experts. And the state says, well, the prosecutor wants us to believe that his knowledge of his falsity isn't imputed to the prosecutor. But we look at NAPU and the other cases, and we say there's a line of cases that say, what are representatives of the state? They're part of the prosecution team. the expert. In this case, he was a member of the state crime lab, is part of the prosecution team. And then you've got the famous case of Trooper Zane. The state bears the responsibility for the false evidence, whether or not they knew it. Okay, one reason I really like NAPU claims is that the standard of review is so favorable, at least on direct appeal. The standard of review, like a hair trigger, particularly like that, you'll see the citation where that comes from. But courts are confused about this because in NAPU they talk about, it might not be in NAPU, it might be in Agers, but in any event, they talk about any reasonable likelihood, it is Agers, any reasonable likelihood that the false testimony could have affected the judgment of the jury. Any reasonable likelihood? What the heck is that? We know about reasonable possibility, the Chapman standard. We know about reasonable probability, the Kodiakis standard. We've got this reasonable likelihood. What the heck is it? It has to be like appeals geeks like me that sort of concentrate on, you know, look to see what the Supreme Court means when it says that, as opposed to how some courts have tried to interpret it. The Supreme Court in Bagley makes absolutely clear that any reasonable likelihood is equivalent to the most defense-friendly standard, the Chapman standard for harmless error. And this is the case, the virtual hair trigger. The prosecution's knowing use of false testimony entails a veritable hair trigger for setting aside the conviction. Well, we know that's not true. There's no such thing as a hair trigger for setting aside a false conviction of any sort. You know, it's really freaking hard. But it's a better standard. I've got another case that's in Chris's memo from the Ninth Circuit in 2011 called Sivak versus Hardison, where they say, it is established that the government if it is established that the government knowingly permitted the introduction of false testimony, reversal is virtually automatic. Again, it probably overstates it, but it's a really good standard. So now for me, the fun part, which is showing you in a series of slides how the FBI examiners, misleadingly at least, I believe falsely, testified about the probative value of their hair match testimony. So we have James HILVERDA in 1978, and this is from an Eighth Circuit opinion. What's the likelihood that any one individual has his hair might meet all of the characteristics of another individual? Well, I would basically have to go to my experience in examining about 2,000 cases that I have seen. Only a couple of occasions, hair from two different people I could not distinguish. That is the classic testimony. I have viewed this many cases. I have only failed to distinguish between knowns this minuscule amount of time. And you're going to, just bear with me, I'll try to go a little faster. You're going to see this play out. And I think these numbers are important. First of all, it's going to show that Michael Malone was not a rogue. They all did this in some fashion or another. So here's the next one. This is James HILVERDA in 1980. Question, is it possible that two individuals could have hairs with the same characteristics? It is possible, but in my personal experience, I rarely have seen it. Only on very rare occasions have I seen hairs of two individuals that show the same characteristics. That's my client, Sante Tribble. The prosecutor used that testimony to argue in closing argument that there was a 1 in 10 million chance that it was anybody other than Sante Tribble. That was not true. I like this picture. Little irrelevant fact. He's hugging his trial lawyer. His trial lawyer was so distraught after having the sentencing for 18-year-old 17-year-old at the time, Sante Tribble, then gets life in prison, that he decided to leave the public defender service. And he answered an ad in our local legal rag for a small government agency looking for a trial lawyer. And there he stayed for the remainder of his career until he retired as the general counsel of the National Security Agency. So the public defender service is not only everywhere, we also hear everything. This is my next client, Kirk Odom. This is Myron Schulberg in 1981. In 10 years, in thousands of analyses, only 8 or 10 times could he not distinguish, even microscopically, between known samples. And so he said it was very rare for it to happen. I should point out, just because we're talking about the numbers here and not just how piss poor the matching is, but in Mr. Tribble's case, when they actually analyzed the 13 hairs in a stocking mask, and the agent had said they were all human head hairs, but only one was suitable for comparison. Well, one of them was from a dog. So okay, so we've seen this with Kirk Odom. Interesting about Kirk Odom's case, in the same vein, is that when we analyzed the hair that was used to convict him, it was not Mr. Odom's, but it was also not the person linked by CODIS to the crime, the convicted sex offender linked by CODIS to the crime. It was a completely random hair. Who knows, maybe left by some crime scene search officer at the time. I also just want to put in a little plug here that the United States of America, well, the United States Attorney's Office for the District of Columbia would not tell us who the CODIS hit was in Mr. Odom's case. We FOIA'd them. We filed a federal lawsuit saying, why won't you tell us who the CODIS hit was? And I'm happy to say that they folded a week ago, and the CODIS hit looks very little like Mr. Odom, and his name is Jeffrey Hunt. Okay, next. This is the infamous Michael Malone in the Donald Gates case. For Donald Gates, he testified in the 8 years, 10,000 cases, only 2 instances in which hairs from 2 different people were so similar that he could not differentiate them. So Michael Malone is an admitted, he's a liar. So, and one of the ways we know that, and one of the ways we knew that years ago, and the Wall Street Journal had done a wonderful article showing this, is that year after year after year, he testified to the same 10,000 cases that he reviewed. He had, as Chris said, a 20-year career at the FBI. Towards the end, he would say it was 2 or 3 times when he could not distinguish between people, but he kept that 10,000 thing going there. So, Agent Michael Warren, can you apply a statistical analysis to a hair association? Oh, I'm not sure if I understand your question properly. I would say this. I probably can't give you a specific number. I can say that of the 5,000 cases that I examined between 81 and 85, that was his career at the FBI, I never found 2 known samples that I couldn't tell apart. Interesting thing about this is that Agent Warren, okay, I'm not saying that there's not another hair out there that could not match the sample from Mr. Martin, because I haven't seen all the hairs in the world. Great qualifier, right? I haven't seen all the hairs in the world, so maybe there's one out there. Interesting thing that he was testifying in 2006, so one would have thought he would have been a little, I don't know, reluctant to go out there quite on the limb that he was, since now we have a DNA revolution that shows how faulty this evidence, how often this evidence has led to wrongful convictions, but there it is. Kevin Martin, just recently, it turns out, they found semen related to his case, and it excluded him as the perpetrator. Bear with me just a minute. Okay, John Quill. Now we're getting really good, because the agent here, he goes from his own personal experience to the personal experiences of the entire lab. So he testifies that he's been there for 9 years. There's 10 agents in the hair unit. He's done about 2,000 examinations in the past 6 months, like he testifies, and it's February, and he says, well, since October. And he says, on 3 different occasions, there have been situations where the hairs have been so alike that we could not distinguish them apart. When we have a situation like that, all the rest of the examiners that we have, maybe a typo there, will come in and take a look at it, so it's a pretty good means of discrimination. So I think they like rang a cowbell. Wait, we got one here. There's two knowns we can't distinguish, and they all gathered around, and it only happened 3 times in his 9 years. So, I was going to say something else. Stephen Mitchell, is sad to say, died while he was in prison. So here's Chester Blythe in '81. During the approximately 1,500 times that you've had the occasion to have 2 known hair samples, how many times, if any, have you had a situation where both known hair samples had identical characteristics? On one occasion that I recall, that I know of, and then he is asked, is this your experience with regard to the whole unit? And he says yes as well. And this is the case, sorry, it took a while to get here, this is the case that I'm working on right now. This is very, very late in the game for microscopic hair analysis, because in late '96, they started using MITO. So he testifies that in the 7 years that he's been in the unit, since 1989, he's had 2,000 to 3,000 cases. I have seen it, I think, 2 times in my career, and neither have been in my own cases. It's a rare enough thing that if anybody in our unit gets 2 hairs that look so close, they'll show it around. I've never had that in my case, but it's very rare to find 2 people, blah, blah, blah. So he's ringing the cowbell too. I never had it. We've got 10 agents. We do thousands and thousands and thousands of cases. So Peter, in his deposition of Michael Malone, had him acknowledge what is probably obvious by his 10,000 in every single case, is that they didn't keep numbers, right? I don't know that they knew how many cases they worked on. If you look at these different agents, you know, it's sort of discrepancies in terms of like how many a year that they would do, because they seem to have different numbers in their whatever. So, I wanted to bring this out for you folks. There's a lot of discussion about if you have state cases. First, let me make the point that the FBI Hair and Fiber Unit was the state laboratory in the early '80s for many, 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 many states. And I took just a real quick look at what I just had from Michael Malone, and he testified in at least 41 different states for the state. So FBI agents went all over the place and gave this kind of testimony. But some state labs did it as well. So here's an example of a case I found when I said state hair experts did it too, and they did it even better. The state's technician who performed hair analysis testified that in analyzing 2,400 hairs per year for 16 years, she had never found a coincidental match. So no bell ringing for her. Here's what Chris was mentioning about the FBI, and Peter told me this, turned me on to this. I didn't know it at the time I wrote my motion. But so in 1985, the FBI it has an international symposium at the FBI lab of hair analysts. And they present papers, and they have panel discussions. And it is available online. So I'm just showing you the cover there, because all you have to do is Google that title, which is what I did, and you can get the whole symposium up there. And it's very interesting, a couple of things, because turns out that other places like France and England were quite not so keen on hair microscopy as the FBI was. But here's a particular thing I want to call to your attention, which Peter called to mine. And they had a criminalistics professor who was, I think, somebody who probably studies statistics and crime. And he was on the panel, and he had a question. He made this comment with respect to, and this panel was sort of a wrap-up, I think, at the end on the evidential value of hair examinations. And he said, this is 1985, I have a problem with the presentation of testimony in court when the expert says, in my experience, I have examined thousands of hairs and I have never found 2 hairs from different sources that were alike. I think that it's very misleading and it is not substantiated by data. So, and then here's just another thing where there's another thing in there about report writing where all these state labs said, yes, the FBI trained them and now we use their model. And one of the things in the FBI model was to include the disclaimer in their report. It's not like a fingerprint. And in my cases, they always say that in court. It's not like a fingerprint, as if in fingerprints, you can actually absolutely identify to the exclusion of everybody else in the world.
Sandy, the only little fact I'd add is one of the things we learned in the FBI review is that there were several hundred state examiners who were trained at the FBI laboratory during a 2-week course that was given over 25 years each year on hair and fibers. And what we also learned was, at the end of the course, what they would do is a mock trial where the state examiners or the FBI agents who want to be certified to testify in court would pretend that they were testifying in a court, and then they would go through a mock cross-examination. Unless and until they offered that kind of testimony about, I've looked at 3,000 hairs and they've never matched, they couldn't pass the course. So they were instructed to do it, and in fact, they were required to do it.
Wow. Can we get that in writing somewhere?
Yes.
Wow. So this testimony is misleading, I think, by design. Is it also false as a matter of fact? That's my challenge to you. So it is, as Chris demonstrated, sorry about that, scientifically invalid. It's unsupported by any data. It's misleading, as we've described, and knowingly so. It corrupted the truth-seeking process of the criminal trial, which is the fundamental due process right that NAPU and all those cases are concerned about, okay? But, so I'm kind of greedy, and I think judges, probably like me, are very concrete, and very granular, and they like facts, and if you call a witness, particularly an FBI agent, someone who's misleading, you really would like to have the goods to show, in fact, they are lying, okay? And you want to be able to demonstrate it. And all of these, I don't think you have to. I think all this is enough. I'm not saying we need more. I just want more. So all of these transcripts made me think, and the Wall Street Journal's compilation of the Malone transcripts is like, what if we looked at these transcripts? What if we examined how many times the FBI was saying, or different agents were saying, at different times, how many cases that they had done, or how many knowns they couldn't tell apart, or how many in the whole unit for those, 9 or 10 years did they ring the bell because there was one of those magical cases. So that's one thing that made me think that maybe we could find out more. And another was sort of a lesson of Hinton, the great ineffective assistance of counsel case, because it's kind of a head snapper. It's kind of a head slapper. You say, really? Because when you read the case, you find out that the defense attorney was only getting $1,000 for his own entire representation, and he thought, but he was wrong, that he could only get, the equivalent of that for his experts. And he didn't realize that when the judge said, well, I think you can get more if you have expenses, that he could go in and get more. Anyway, Hinton is a wonderful case, but this is what I'm saying. It's really, really concrete. There was a statute. It said you were entitled to get more. You didn't ask for it. You were ineffective. So I would like equally to say, you came into court. You said that there was only this number of times where you couldn't compare knowns to knowns. You said you testified this many times. You said this was experience of the FBI. You misled, and you know what? You didn't keep those numbers, and to the extent that there are numbers, they show that you are doing more than just simply misleading. So here is the other inspiration for this, and that is the poor, sad story of another client of mine, Johnny Moore. So Johnny Moore was convicted when he was charged when he was 17 years old of 2 sexual assaults. And I took his, and he is still in prison, and he has been denied parole 8 times because he refuses to acknowledge his culpability, so he doesn't really look like he's ready for the street, and also he does things that would be completely legal in freedom, like want to smoke a cigarette occasionally or take an extra piece of chicken. And anyway, so he's got these little disciplinary things and he won't acknowledge his guilt. So I look at Johnny Moore's case, and we can't find the physical evidence, so we can't do any DNA testing. So you might wonder, because I'm talking about hair case, well, maybe there was bad hair testimony, so you could just use one of these creative theories to talk about bad hair testimony. But it turns out we have to ring the bell, because in Johnny Moore's case, they couldn't tell the two knowns apart. This is from the FBI report. Specimens K1 and K6, and that's the victim and Mr. Moore, are so nearly alike in microscopic characteristics that it was not possible to distinguish one sample from the other. Therefore, it was not possible to conclude that the above described pubic hairs could have come from one of these known sources to the exclusion of the other. Bingo, I got it. I have only done 6 cases. I mean, I've looked at others. I have only done 6 cases. And I got one of them. And when you see these folks testify, you know, the prosecutors would extrapolate it out. So there's 10 examiners and 9 years and 2,000 cases. That's like hundreds of thousands of cases where you almost never found a known. So I got one. And this was to the same effect, the stipulation read at Mr. Moore's trial. Well, it won't help Mr. Moore because I can't bring a challenge about bad hair testimony because they didn't introduce any. But it made me think, maybe there are others. Maybe we can find more cases like this. And maybe we can demonstrate that I want one. So everybody look in their files, okay? I want one from Fram, where he found another, I want one instant where he had 2 knowns and there was a report with his initials on it and he couldn't tell them apart, okay? So a couple of things. I don't think you will learn this from this aspect of it, from the FBI hair review, because they're reviewing cases, and when they find cases where there was a positive association between you know, the questioned hair and the defendant, then that's something they'll look at the nature of the testimony, right? So in the District of Columbia, so look in your old cases, right, where you have FBI reports and hair wasn't introduced, and let's find out why. Maybe it's like Johnny Moore. But here's another thing about the District of Columbia. So I can't do a presentation like this without taking first a jab at the United States Attorney for the District of Columbia, my opponent. So after Mr. Gates' exoneration, we asked the District of Columbia, the United States Attorney's Office for the District of Columbia, to do a review of all hair cases in the District of Columbia. Thanks. To do a review of all hair cases in the District of Columbia. And it was letters to the court, and they wrote me back. And they said, oh, I dearly love this. It's a letter is attached to my motion. They said, with all due respect to the Public Defender Service, there is no reason in the world to engage in that kind of a review. There's no scientific or legal or practical basis to engage in that kind of a review. So then we had Sante Tribble and Kirk Odom, and now they announced that they were doing a review, independent of the FBI review. So what we learned is that PDS is sort of shut out of the review, but go figure. But we learned that they reviewed 2,000 FBI reports with 2,000 cases in which the FBI reported on examinations in the hair and fiber unit in DC cases. Of those, there were 200 positive associations, and of those, 100 people were found guilty. So I wondered, what about those 1,800 cases where there wasn't a positive association? I'm assuming, although I don't know, that maybe maybe a vast majority, I don't know, but a huge number of those, there were no hairs, or there were no hairs suitable for comparison, or the hairs didn't match, or the results were inconclusive. But I'm hoping that some of those, even like a significant number of those, are cases where there was no association because they couldn't tell the knowns apart. So I have drafted a discovery motion seeking to find that information. It's in your materials as well. I don't have an order for the court. I have no results on this. And so I am asking you to audit your own cases, to review your transcripts. Let's marry up their testimony in one case against their testimony in other cases. And the post-discovery, post-conviction discovery, if your own jurisdiction is doing hair reviews, or if you have any, think of creative ways in which you can discover this from your opponent. There's really solid case law. Harris versus Nelson, it begins with, where the court said there's a right for discovery with, with permission of the court in habeas cases. Bracey versus Gramley, if you don't know it, you should read it just because it's such a hoot, because it's Operation Greylord, or one of those things where I think Chicago judges were on the take. And so the theory here for post-conviction relief was, my attorney was the judge who accepted bribes. My attorney used to be his law clerk. And I was found guilty, or I had bad rulings against me, or whatever. And on either side of me, I think the defense attorneys were paying bribes to the judge. So I think the judge needed some cover. He couldn't acquit everybody. So I want to find out, not in my own case, I know what happened in my case, I want to find out in those other cases with the judges, were they spending bribes? And the United States Supreme Court says his allegations might not be borne out once he goes and looks at it, but he said enough to get him a right to discover. So I think we have enough to say, we don't know if they were actually, in fact, lying, but we have enough to deeply suspect that they were. And if we can show what happened in other cases, it's relevant to what happened in ours. So go get them. Thanks.
Just, you can start to have a question for the leadership. Just two other things. One is, except for one person I know in this audience who definitely has a scientific background, most of us who are lawyers don't have a background in statistics and probabilities. Obviously, I urge you to talk to people who do. But what you have to appreciate here is what Sandy is saying is not only were folks lying when they said, I looked at 5,000 cases, 10,000 cases, 3,500 cases, or extrapolated out to 50,000 cases with only two coincidental matches or whatever, that they kept no logs, no records. They didn't know how many cases they did. They never noted when there was a coincidental match. There was simply no records at all. The numbers were out of thin air. And that they're lying about. But they're also lying, and you wouldn't know this necessarily if you don't have a background in statistics, and they were definitely misleading when they would say, twice in 5,000 cases, because to a lay person, the twice in 5,000 cases sounds like, aha, so the odds of a coincidental match are only 1 in 2,500. Or for Malone, when he said this 2 in 10,000, aha, the odds of a coincidental match are only 1 in 5,000. But as any person who has a background in statistics and probabilities will tell you, that's not the odds, okay? And that, in fact, if you want to be able to make a statement like that, you would have had to do pairwise comparisons with all the other cases each examiner looked at over the course of their career. Because, for instance, when they simply say, I didn't see a coincidental match, all they're saying is, when I looked at the known hair plucked from the victim and the known hairs plucked from the defendant, I was always able to distinguish them except on 2 occasions. But what they didn't know is whether, if I compared, let's say, the victim's hair to a victim I looked at yesterday or last week or 2 weeks ago, that it wouldn't be indistinguishable. So that in itself is misleading. There's no question about it. So one question, though, I did have for both of you is, there's another type of cause of action which could arise, which is where, which neither of you really went into, which is a situation where, let's say the forensic examiner basically testifies okay, but the prosecutor makes a clearly scientifically invalid and egregious closing statement, grossly exaggerating the probative value of the evidence, and doing it knowingly, okay, and doing it knowingly. What burden would apply in that situation?
So I think the problem with that scenario is if there was no basis because it wasn't in evidence, so the expert didn't testify in that fashion, it's sort of the 1 in 10 million with the prosecutor in Mr. Tribble's case, I think you probably have a problem at the get-go with a failure to object. So I think you're in a plain error standard.
What happens if you objected and the judge simply, overruled the objection?
And you know, that is the truth, because when I talked to people about the 1 in 10 million and there was no objection, and the response was, and I think it was Brandon Garrett when I spoke to him about this a year or two ago, was, I've looked at those cases and lots of times they did object and there wasn't any Court of Appeals opinions that I saw where the court would say, oh, that's so prejudicial that we'll give you a new trial. But I think you make a really good, so I don't know the answer to that question I just raised, that there might be that issue, but I think you make a really good point in terms of showing when you do, whatever your claim is, the significance of the claim, the materiality of the claim, because when you have the state arguing it to the jury, it's a much better case to say that it mattered. I don't know, Chris, do you have any thoughts on
No,
it?
it strikes me straight up misconduct and the misuse of summation misconduct.
And what's the
probably
standard?
an
What's
IAC
the
claim, I
standard?
would think. Of a prosecutor, I don't think you could get relief on that in post-conviction. I think it's plain
The
error.
IAC, the direct appeal is plain error, but the IAC is the failure to object.
Right.
So you might have a basis there.
Right, yeah. I would, and I bet that was common failure to object on that based on ignorance alone.
Speaking of ignorance, you all want to have lunch. Thanks.